deal with taxes and insurance claims. It's not a general power of attorney. It won't deal with other financial institutions. It won't deal with banking. So, and I often have clients get pushed back when they actually present documents to some of those places that say they want their own. And I say, you have to tell me why mine's deficient. It's not correct when they say, you have to use mine. They're wrong. But I finally get to the legal department and push back. But the idea is that's another factor to keep in mind.
That's good to know.
Good to know, Lois.
All right.
I have another question.
No, Lois,
Yeah.
because we're running a little bit long, and I
Oh,
want to get
okay.
to Sherry because I know she had a question as well.
Oh, sorry.
Thanks,
Sorry.
Mary. Just a quick question, probably for Lisa. If a will was crafted by a New York attorney as recently as 2019, let's say, but then the party moved to New Jersey. So the documents reflect a New York address, et cetera, but now the party lives in New Jersey. All the contents, the beneficiaries and who the executor is and the powers of attorney, everything is still the intention, but the person no longer lives in New York. Will that will still apply?
So Laurie, I would say yes.
So wills
yeah.
have a big
I want to say something. I'm really super sorry. As soon as Laurie's done, I have to jump off. I have another meeting that's like started at 1. So, I did want to say something really, really quickly before Laurie, you answered. When we're looking at the power, I know you mentioned the will, but I'm also want to talk about the power of attorney documents, just kind of go back to that. There are two kinds of, we've been talking about durable financial powers of attorney, which become effective as soon as they're executed. There are times I have found as a geriatric care manager that people have executed these, what's called a springing power of attorney. And I'm going to jump off and let, maybe if Laurie wants to make a comment, but the difference between the two is a springing power of attorney often needs something to spring into effect. And what that is, for instance, two doctors, oftentimes it's two doctors, one of them being a psychiatrist, to determine that someone does not lack capacity. I have had real problems with my clients because if that's the kind of power of attorney that they have and they have dementia and someone else needs to make that decision for them, we have to get two doctors now to say that. And sometimes doctors don't want to say that.
I don't recommend.
They don't want to be put on the spot like that.
Just don't want to say anything.
Thank you, Lee. I don't recommend springing powers of attorney. I really do it because of what Lisa said. It puts an impediment and it takes time to get it done. And then the financial institution pushes back on whether or not they.
You have to wait. You have to wait for something to happen.
Right.
And the other piece of that, just to go along with that, and then I will jump off and let Laurie end, is I'm not a fan of co-agents. Sometimes you need that, but anything that puts an impediment into someone being able to do their job is hard enough because they're making decisions and acting on someone else's behalf, right? So now we don't want to make it harder. And I once heard a very wise woman say that if you trust someone when you lack capacity, you should be able to trust them when they have it.
Yeah.
And that's what I usually say to people when they're going to see their lawyer and they're trying to decide what they should do. And I want, my job isn't to do the documents. It's more to provide a little bit of, I want to say the backstory so that when people are making choices as to who they're going to, there is a time and a place. If you have a professional that has to act in that capacity because you feel you have no one else, you may want to have that joint checks and balances. But other than that, if it's not set up for checks and balances, I find the right person. I need to thank you all.
Thank you, Lee.
Thanks, Lisa.
Thank you, Lisa.
Have a great day.
Thanks, Lee. So
Thanks,
Shari, the answer to your question is, if the will is executed appropriately, and again, we always look at people's documents as part of our free consultation. The idea is that it could be still recognized in New York, but you have to understand that you probate a will in the state in which the person lives, not dies. So, like my mom passed away in Sloan, in New York, but she lived in Rockaway, New Jersey. So her estate was probated in New Jersey. So the idea though is that a New York will could still be valid. The idea though is just making sure when it still has the clauses that you want. And the powers of attorney are a little bit different in a sense that some states have specific language. Some states that they want, that some states have specific language that they want in it. And they, like we cite in New Jersey, a statute, a banking statute. So New York is a templated state. It uses a templated format of like fill-ins. So it would be recognized in New Jersey. It's just that I would have more comprehensive language in New Jersey because I'm not limited to the template because it's a statutory. So to me, if you move to another state, I do recommend that you update your powers of attorney to reflect the New Jersey statutes and relevant, but it's not meaning that you wouldn't be able to have some ability to still act on someone's behalf. It could be recognized. Because remember, it really also depends on where your financial institutions are. If you move to Jersey, but all of your banking and all of your accounts are in New York, then you would want the New York templated still one, you know, the statutory format. So it's not necessarily deficient in and of itself.
Okay, thank you.
All right, great. Any other final questions anybody else has that are pressing? Although certainly encourage you to reach out to any of our
No,
panelists.
thank you, Barry, for
So as
organizing
well,
this,
thank
you.
overseeing it.
not a
Jeremy.
problem. Let me just share
Moral
a screen here. Hang on one
The moral of the
second.
story for everybody to pay attention to is start now.
Yes,
Plan today.
Yep.
Because if you don't plan now, something's gonna happen and you won't have as many choices.
yes.
Absolutely. So everybody should see on their screen contact information for all of our panelists. Thank you to Donna and Laurie and Lisa and Jeremy. And
Thank
thank
you.
you all very
Thank you
much
for
for
helping
joining
and-
us
Thank you.
We
Uh,
Thank you.
appreciate it.
this
Thank you for putting
afternoon.
this together.
So,
Bye, thank you,
all
everyone.
right, we'll see you all soon.
Just
Thanks.
so you know, for those of you who might want to reach out to Laurie, she does have a no fee consultation. So there's no harm in reaching out and making a call and having a conversation. I
And
just,
if anybody has a website that they need to have built,
Go to Barry.
my brother from another mother, Barry.
Yes.
All right, I'm signing off. Thank you, everyone. I have to go to a meeting.
Thanks, Lori.
Ditto, thank you.
All right,
Thank
thanks,
you.
everybody.
Thank you, everybody.
Gary, thank
Okay.
you, Jeremy, thank you.
Thanks.
Got it. Bye-bye.
Bye.